Welcome to Credit and Bankruptcy with Reed Allmand. Reclaim your power for financial independence. And now, your host, Reed Allmand.
Welcome, everyone. Got another great show planned for you today. We're going to be talking about the situation that happens after your case is filed. What do you need to know to make sure that your bankruptcy case is going to be a success? And I have a guest host with me today. It's Danielle Gaines. Danielle, thank you for joining us.
Thank you for having me. I appreciate it.
All right. So I'm really excited to dig in. We're going to have a focus on each chapter of bankruptcy. So we're going to start with Chapter 7 and what you should expect after filing up through the point of discharging your case. And then we're going to switch over and do the same thing for Chapter 13 because there's differences, right?
Oh, yeah. Big differences.
Okay. All right. So we're going to go ahead and start now with Chapter 7. So you've just filed your bankruptcy case. Congratulations. We got your Chapter 7 filed. We want to make sure that you're going to be a success. And so we're going to go over some key information for you right now to make sure that happens. All right. What is the first thing that people encounter right after their bankruptcy case is filed?
Yeah, so right after your case is filed, we really recommend that you pay attention to what creditors have been included. If we need to add any creditors that you might have missed, you get a statement in the mail and you don't know, did I add them? Well, were they included? Were they not included? And right from the beginning, right, you now have an automatic stay in place.
Right.
And so your home, your car are protected.
Yeah.
And so if you're still being contacted by a car creditor or they try to repossess your vehicle or your landlord is trying to evict you, and they're not allowed to do that, right?
Exactly.
And so we need to know that immediately so that we can stop that from happening, right?
Exactly. So we're going to drill down into all those things in greater detail. But Danielle is absolutely correct. You filed a bankruptcy case now, the automatic stay is in place. You have your case number. That's going to be one of the most important things that you're going to need to keep track of because you're going to use that case number to tell anybody who calls you, I filed bankruptcy with Allmand Law Firm and here's my case number. And so as soon as you file the case, we're going to notify all of your creditors that are on the bankruptcy schedule. So they're going to get a little copy from the bankruptcy court that says, the bankruptcy case is filed. On there, it's going to have the case number. It's going to have the name of the person who's filed bankruptcy. It's going to have the date and time of the meeting of creditors, which it's called the meeting of creditors, but we both know very rarely do any creditors show up.
Very rarely, yes.
It's typically just a Chapter 7 trustee and our law firm with our client. And then also it's going to tell them deadlines in the case, like how long do they have to object to this case if they have an objection. So that puts them on notice. That's the document that they get directly from the court saying, hey, this person has filed bankruptcy. The good thing about that is you should expect within 1 to 2 weeks after filing that these creditors are going to be able to get all this information loaded into their system. Okay? Because a common issue that we have is somebody would be like, we filed your case, congratulations, here's your case number. And then they call us or they email us to say, I just got a phone call from Toyota. I just got a phone call from MasterCard and I just got this statement. Okay, so that's probably an inadvertent situation because these big creditors don't work instantaneously. They get the notice. It has to go to this department, to that department. They have to update their database. So initially when a case is just filed, we want to make sure that we just give them the case number, tell them we're represented by Allmand Law Firm, keep track of those phone calls. And then once we get past to the second week or the third week and they're still contacting you, then we have a problem. Okay. So you mentioned something I wanted to go into greater detail about.
So, I jumped ahead.
That's okay. So let's talk about, I have filed my case and I just got this notice from this creditor and I totally forgot about them. I spaced out. I do owe this medical debt. I didn't list it. What do I do?
Yeah, so if you let us know and you provide us with the information, the creditor, their address, account number, when the debt was incurred, the date, and we can add this creditor to your case. There's a nominal filing fee that's involved, but we want to make sure that every creditor is accounted for so that we can get it all discharged for you.
Right. All right, so we're going to run through like a little checklist so that right now I need to add this creditor. Number one, from what I hear you saying, is they need to get us the name, address, account number, and the amount they owe. So we got that critical information to fill out the paperwork. If you have a statement that you received from the creditor, we would love to have that. If you don't have a statement, but you have all that critical information, we can do it. If you just send us, hey, I forgot to list MasterCard, that's not going to work. We need the account number, the address, and the information, because it's very important we mail it to the correct department. So step 1, tell us who you missed and all the details about the case. Step 2, we have to amend the bankruptcy schedules, right?
Yeah, we're going to have to go in and amend your schedules and make sure that they're listed correctly.
Okay, so we amend those schedules, and then we're going to send you the bankruptcy schedules. You have to sign off on it. It requires your review and signature. Right now, since we're dealing with COVID, we're allowed by the bankruptcy courts to have you electronically sign those amendments with a DocuSign or another e-provider, and then send us the original signatures so that we can file a notice with the court within 30 days that we have the actual blue copy in our hands. That is something that's very important. So if you swing by, you can swing by the office and just sign that. You can mail it, return it to us. There's different ways for us to address that. So now we know the creditor, we've amended the schedules. Now we have to file it with the court. And you mentioned something important. When we file it with the court, we have to pay a fee to amend the schedules. Do you know what that fee is?
It's $31.
Okay. So as of the date of us recording this, it's $31. Sometimes it goes up periodically, but so when we file this, we have to pay the court. And so we'll need you to reimburse us for that expense to file it. Let's say they forgot 10 creditors. Are they going to have to pay $310?
No, get us all the information and we'll do it one time.
Right, exactly.
So make sure that you really review what you have and send it all to us at the same time.
So if you have one creditor or you have 20, it's still $31 if we all amend it and include everybody at once. So that's a very good point. If they have more than one, to let us know. Otherwise, we're going to have to keep paying for that.
Right.
Okay. Is there a deadline? When's the deadline for us to get this amendment filed to add this person?
So in a Chapter 7, we just need to do it before their case is discharged. So you do have that full case life to get it done, but let's get it done sooner rather than later.
Yes. Yeah.
Because we really don't want to wait until the last minute.
Right. So the danger of waiting to the last minute is that notice I told you that gets mailed out to the creditors, it has on there the deadlines for them to object to your case. And if you add it a week before the deadline's out there, most likely they're going to file a motion with the court potentially and say, look, we've only had a week notice of this. We didn't get to go to the creditors meeting. We have additional questions. We want this deadline extended. And so now you're going to be potentially stuck in bankruptcy longer until they have an opportunity to review it. So the sooner the better is basically what we're saying. Good point. All right. So we have another fun item potentially for our Chapter 7 clients that you're going to need to address after the case is filed. And what would that be?
So reaffirmations, right? So what do you want to do with your secured assets, your home, your car, after your case has been discharged? Do you want to reaffirm that debt with the creditor? And so reaffirmations are an important part of the process. And the sooner we can get it taken care of, the better. We really want to be able to have the time to negotiate with the creditor what those terms are for the reaffirmation. And get it filed before your case is discharged.
Right. So important things regarding reaffirmations is when you file a Chapter 7 bankruptcy case, all of your debt is discharged, including secured debt. And what I mean by that is your financial obligation is discharged. But as you know, if you have a car or you have a house, there's not just the note that has the debt, there's also the lien on the property. So if you want to keep property, you still have to end up paying, you have to pay off the debt, even though you're financially not obligated to. And so if you decide you want to keep the car, you want to keep their house, then you're going to need to do potentially a couple of things. Number one, you can reaffirm the debt. You can choose to not reaffirm it and keep it and just keep making direct payments. Or 3, you can surrender the property. So we'll briefly touch on those real quick. So if you want to surrender the property, we list that on your intentions in the bankruptcy case that, hey, we no longer want this property, we're going to give it back. Sometimes people with a house may think, I'm not so sure if I want to commit to having to pay this mortgage, so I'm not going to reaffirm the debt. And under case law in our jurisdiction here, as long as they keep up with the mortgage payments, they're not going to foreclose on the property. and they'll still eventually get the deed to the property once they're done. So that may be an option for people. They should be aware, though, that if you choose to do this option, they're not going to report it to your credit bureau when you make payments on time, and they potentially may not send you statements or make other loss mitigation programs available to you because technically the debt's wiped out and they don't want to get sued. So if you go into that knowing that, and potentially there's going to have to be workarounds if you want to refinance or do a modification in the future, all for it. So now back to reaffirmations. So we got off of reaffirmations. So a reaffirmation is a legal document in the bankruptcy court that says, I'm aware that I did discharge this debt, but I agree to be financially responsible for it again. I want to revive the terms of that contract with the car creditor, and I'm going to be on the hook. And so when this bankruptcy case is over, if I don't make that car payment, they can repossess it. Then they can sell it at auction, and then they can sue me and get the money that they didn't get at the auction. Okay, so that's the risk. You're returning back in that situation. So if you are prepared to do that and you want to protect that, now with cars, it's not necessarily optional to do a reaffirmation. You can't just keep making the payments and then after the bankruptcy be able to keep the car if you don't do a reaffirmation. Unfortunately, there's case law out there that says that even if you're current, if you choose not to reaffirm the debt and the bankruptcy case is discharged, the car creditor can still repossess the car from you even if you're 100% current because you didn't reaffirm the debt. So different car creditors have different policies. We can give you some guidance on that, but that is a potential out there.
Yeah, and we've also noticed recently that some mortgage lenders will not later do forbearances for clients that did not do a reaffirmation. So if you elected to retain current throughout your bankruptcy with your mortgage, and then a year later tried to request a forbearance, they're not willing to work with you on that.
Exactly. All right. So that was a quick overview of the types of things you can choose. It's called your intentions. In the bankruptcy schedules, it's called statement of intentions. We go through there, you make that election. So after the case is filed, we have to follow through with those elections. And so walk me through really quickly, what is the process like for somebody who's decided to reaffirm the debt? What steps have to happen in order for that reaffirmation agreement to be signed and enter with the court?
Yeah, so, on our end, we're going to request the reaffirmation from the creditor. Once we have obtained that, we're going to contact you to come in and sign it. Unfortunately, most of the creditors are not allowing electronic signatures on the reaffirmation, so we do require an original signature on that. We can mail it to you, and that is absolutely an option, and you can mail it back to us, or you can come to our office and sign it. Once it's signed, reviewed by the attorney and signed, we return it back to the creditor who reviews and then files it with the court.
Yeah. So it's like... I was going to say pass the chicken, but my country may be showing. I don't know if that's even a term.
I've never heard that before. But yeah, it's very, we get it from them.
Yes.
We get you to sign it. We send it back and then they file it.
So we have to ask them for it. Then we have to get it. Then we have to get it to you to get it signed. Then we get it back from you. Then we have to get it to the attorney to review and sign in Allmand law. Then we have to get it back to the creditor for the creditor's attorney to sign. And then the creditor has to file with the court. That's a lot of steps.
It is. It's pretty smooth moving if you are responsive, right? Once we get it from the creditor and come in and sign it, and we can move it through the process pretty quickly. But it isn't something that we can do in a week or 2 weeks, right? So when we're working with you to work through this process, it's super important to have that partnership that you are responsive when we need you to come in and sign it so that we can move it through quickly and we can get it back. Okay.
And since there are that many steps, that's the reason why there's a lot of time and energy put in between for the law firm to make that happen. It's compared to somebody who chooses not to reaffirm the debt.
Right.
All right. So we're going to transition on now, and we're going to talk about some other things that are important after your Chapter 7 case is filed, and that's incurring debt. So in a Chapter 7, unlike a Chapter 13, if you want to reaffirm a debt, we talked about that, but what if you want to buy something? You want to buy a car, you want to buy a house. Can you buy something after the bankruptcy case is filed?
Yeah, so one of the great benefits of the Chapter 7 is that you can incur debt without permission from the court. If you need to purchase a new vehicle or you want to buy a home, you don't need that permissions, right? And so it's unique in that.
Right, exactly. So can I buy a car or house after my bankruptcy case is filed, but before it's discharged? The answer to Chapter 7 is yes. Some tips and things to watch out for is we want to make sure that even though you can do that without court permission, that whatever you're buying, hopefully you're not going to be buying a Ferrari and listing on the application that you make $200,000 a year when on your bankruptcy schedules you said you made $10,000. So we want to make sure that your financial application for the occurrence of debt and your bankruptcy schedules match, because you may potentially be subjecting yourself to making a false statement either on the bankruptcy case or a false statement on those financial documents, when can carry severe consequences. All right. So now let's shift gears for just a second, and we're going to ask the question. Now, I filed my bankruptcy case. I have a 341 coming up. What is a 341 meeting? What's going to happen? And what should I be prepared for?
Yeah, so the 341 meeting or meeting of creditors, so 341, I believe, is the bankruptcy code number for it. That's why it's called the 341 meeting. But this is the meeting of creditors. And so you, the trustee, an attorney from our office, and then any creditors who wish to weigh in will meet together and just verify information that were included in your schedules on the record, right?
Right.
So it's not done before a judge. I know a lot of people freak out. They think it's like in a courtroom and they're thinking law and order kind of stuff, but it's a little less formal than that, right? Currently, in the situations that we're in with COVID, these are done by telephone in a Chapter 7. And so you can do them from anywhere, right? If you're on vacation, if you're at work, you take your lunch break for your 341. I mean, it's very convenient. And you just call in, and when they call your name,
right,
you know, our attorney will weigh in and you'll answer the questions that the trustee as well as our attorney ask you on record. It's pretty painless. It's, you know, it's just to clarify that everything that's there is accurate. So it's really quick.
Yeah. So as the time we're recording this, you know, we're in August of 2020, and the United States trustee has signed an order that all cases filed up through October 14th of 2020 will have their hearings, their 341 meetings, conducted telephonically. And so what'll happen is on the 341 notice, it'll give you a number that you need to call into and a time. And so then you'll be in this, and you'll be on mute, and there'll be potentially 10 to 15 people that are also in that same time block, and they'll call you one by one and you'll go through everything. We'll also be on the phone as your counsel representing you. You should be prepared to make sure that we have a good driver's license and Social Security on file for you, and we have to deliver that to the Chapter 7 trustee in advance. When all this is over with COVID and after October, we don't know if you're going to be required to show up in person. If you do show up in person, you have the date, the time, the location, and you have to bring your original driver's license, Social Security card. I've had some people be like, oh, I forgot it. Unfortunately, the meeting cannot go forward, and the meeting will have to be rescheduled. You'll have to take off of work. You'll have to come back down there again, and potentially there may also be a motion to dismiss filed. Also, there may be additional attorney's fees for that. So it's very important that you have your identification. Virtually, we get it from them in advance and send it over there. So next, you're going to be placed under oath. So you're not in a courtroom, but everything you say is going to be under penalty of perjury. If you filed a joint case with your spouse, then that person will also need to be on the phone or with you in person. They both have to be there. You may both answer the questions simultaneously, or sometimes you're given the election to just have one party answer the questions, and then at the end, the person who did not answer the questions will be asked, do you agree with everything that was said, and do you have any changes or corrections to be made? Very quickly, some of the questions that you're going to be asked at your 341 meeting, you're going to be asked to state your name and your address for the record. You're going to be asked to explain why you had to file for bankruptcy. And so common answers to that question are, I had a medical illness, I had a divorce, I lost my job, I got overextended and could not afford to pay for all my debts, The Chapter 7 trustee is looking for a quick explanation. They're not necessarily looking for a response that starts, it all started back in 1960, and a narrative. In general, when you're under oath and you're giving testimony, direct and short answers that are truthful is the best way to go.
Yeah, so I know we typically advise yes, no answers. If you have to elaborate, be clear, concise, and direct, right? Yeah. We don't want any stretching of the truth or anything like that, or omitting anything. That's not what we're saying. We just want it very direct and to the point.
Yeah, and so if you are feeling anxious or stressed, and you're feeling the need to confess that something was not listed on your bankruptcy case, we'd prefer if you do that to us before you're under oath, because we'd like to hear it before you're under oath so we can give you advice as your attorney on what needs to happen. We may want to go ahead and reset the meeting, go back, amend the schedules, accurately disclose everything, talk to you about the situation, get all the answers, then hearing about it for the first time. It sounds strange, but when some people feel that pressure, they're like, oh, I forgot to mention that I own part of a house with a sister or brother, and or I didn't do this or that. So we want to avoid that. Number two, or maybe we're on to the third question right now, is going to ask, did you help your attorney prepare these bankruptcy schedules? Okay. An additional question is, did I list all of my assets? Everybody that owe money to, did I list all of that on the bankruptcy case as well? So you need to list all of your creditors. We're also going to ask if you've sold or transferred any property out of the ordinary course of business in the last 2 years. Have you sold or transferred any property to a family member? Because that's significant, because that may be a preferential transfer. We're going to ask if you own any stocks, bonds, or mutual funds. Going to ask if you are a trustee or recipient beneficiary of any trusts. And also, we're going to ask, are you aware of the windfall rule? So what is the windfall rule?
That's a really good question. I want to say, is it like if you suddenly come into a large amount of money, right?
Exactly.
Yeah.
So within 6 months of filing your bankruptcy case, you're under an obligation to report to the Chapter 7 trustee any windfalls of money. So, for example, did you win the lottery? Did you receive an inheritance? Did you come into money that you did not have when you filed the case? You have to report it. After that 6-month window happens, and it's 6 months and 1 day, and you hit all those lotto tickets and you win $50 million, what happens? I'll tell you, it's all yours. You don't have to notify the trustee or attorney that in. So, but during that 6-month period from the date of filing, you are under an obligation to report that and also not spend those funds until we talk about that, because you may have the opportunity now where you're in a position where you could pay those creditors back, and you have an obligation to report that to the trustee. All right. So I think we've covered the majority of what's going to happen at that 341 meeting. There's no reason to be stressed. We're there to help you. Ask us any questions you have or concerns before we start the case. Don't be afraid to speak up and say, can we go off the record? Can we take a break? I need to talk to my attorney. Okay? There's absolutely nothing wrong with that. I would much rather you do that than start down some answer or something that's potentially going to cause problems.
Yeah, and we will provide you with a list of the potential questions or the questions that are asked most frequently as well, so that you have that and you can kind of look it over prior to the 341 meeting.
All right, so we talked about what's going to happen at the meeting, but I think we also skipped over something important. What documents do we need to make sure? We touched on that. So what documents do you need for the 341 meeting?
Yeah, so prior to the 341, we are required to provide to the trustee certain documents. Currently, the driver's license and social security card, right? So we need a current photo driver's license, so an ID card, passport, driver's license that is not expired, and then a social security card or a W-2 of the current year that has your social security number on it if you don't have access to your card. Those are going to be your identity verifications, and they need to be sent to the trustee before.
Right, exactly. So number one, you have to have a government issued photo ID. So that can be a driver's license, that can be a passport, That can be a military ID. We've even had an Indian reservation ID. So if it's a government entity that issues that photo identification, we can use that for your meeting. If you don't have a driver's license in Texas, but you have an identification card, we can also use that. That's part one. Part two is the Social Security card. The best is the Social Security card itself. I mean, that really is what it is. And the only other thing we can take is a W-2 issued by the IRS. And the reason is because it's not a document you've created. It's a document from the federal government that has your Social Security number on there. But more and more people are moving away from including your full Social Security number on anything. And so you're going to need that card. So if you don't have a card, make sure you get the Social Security Administration and get that ordered. Right now, they're running a huge backlog and it's taking many weeks to get those. So you don't want to delay that. All right. Another thing that I want to make sure you're aware of is before the 341 meeting, you're required to complete a financial management course. So before you filed the bankruptcy case, you completed a credit counseling course. And then after the case is filed, you're required to do this financial management course. There is a deadline that is shortly right around the time of the 341 meeting. I shouldn't even be telling you people this because I don't want them to put it off, but as long as it's done before the end of your bankruptcy case, it's fine. But it's really dangerous to mess around with this. And can you tell us why?
Yeah, so here's the thing. So Chapter 7, while 3 months seems like a long time, it goes pretty quickly, right? And the more you can get taken care of at the beginning, the better. We don't want you to forget that you have to take the second course and you find out 2 weeks before your discharge that, oh my goodness, I forgot I need to take this course, right? So we recommend, and we actually really talk about it before the 341 meeting. We really like you to complete it before then. If we get to discharge and your financial management course has not been taken and filed with the court, your case is closed without discharge. So you just did all of this for nothing, right?
Exactly.
And there's a huge fee involved in reopening your case just to file this course. And so we don't want to run into that situation with you. So the sooner you take the course, just the better.
Exactly. And so there's a couple tips that I would like to share with people about the financial management course. Is number one, when we prepare your schedules with the attorney, you're reviewing everything, going over it, you get an instruction sheet that lets you know how to complete that credit course. We have 2 vendors that we recommend where we have pre-negotiated discounted fees. And when you log into those providers and use our law firm ID, as soon as you complete that course, it's automatically filed with the bankruptcy court and we're automatically notified, so we make sure it gets done. After you file the bankruptcy course, you're going to be getting solicitations from all these financial management course providers, solicitations from people wanting to incur debt. Some of them are misleading and confusing. And we've run into a situation before where somebody will use one of these other providers, will take the course, they'll pay an extra fee for it to be filed with the court. It doesn't get filed with the court, then the case is closed without entry of discharge. And that means all the money that you put into this and effort you put in to file the case and get it, if that course is not on file, it's over. You still owe everybody the money and you have a bankruptcy under credit. And then it's very expensive. There's additional $650 of attorney's fees to file a motion to reopen it and then do that course. Otherwise, you can just do the course for $25 as soon as you file the case and have the case number and put it behind you. So the sooner you can do it, the better is the moral of the story.
Super crazy consequences to just take a credit counseling course, right? So just take the course.
Okay. All right. So now, one thing that we haven't touched on that I think is very important for somebody who's just filed a Chapter 7 is, what do you need to do if a creditor continues to contact you directly or send you statements after your Chapter 7 bankruptcy case is filed?
Yeah, so we want to keep a log of everything. We want you to write it down. When did they call? Who was it? What was the phone number? Who did you talk to? If possible, record the call. If you're receiving emails or text messages, we want to save all of that, screenshot it. And we really want to have that information. First, so that we can do something about it. Second, because we may potentially be building a case for after with discharge violations. And so the information that we gather as it's happening is going to benefit us later in the long run. So just log it all, let us know, right?
Yeah.
So we can take care of it. And then let's work together to build the data up.
Exactly. So Danielle is correct. As soon as you receive that, whatever the contact may be, it may be a phone call or it may be something in writing. If you get a statement or a notice from the creditor, we want you to go to our portal and upload that document directly into your case file. We need proof of what they sent you and what it was saying. To number one, make sure there's any issues that need to be addressed are addressed in the bankruptcy. And number two, if they're violating the bankruptcy discharge or automatic stay, I should say, at this point in the case, then you may have potential cause of action for them for not doing that. And then we can follow up with them and so forth. So it's real easy to log into your portal, select add a document, and upload that to there, and then also keep the phone records. Now, you mentioned recording the call. There's only one caution I say. In Texas, we're a one-party state, which means that as long as one party knows there's a recording, that's all you have to do. However, sometimes these credit collectors are in other states where the laws are different. So if you are going to record them, you have to say, I'm recording this phone call, and you give them notice so that they consent to being recorded. Otherwise, there could potentially be in violation of another state's law, like California has to have a two-party consent. Okay? All right. So is that basically it for somebody who has a creditor that's still harassing them? Okay?
Yeah, pretty much.
Yeah. So make it short and sweet. Keep your documentation and do that. Maybe, why am I going to this trouble? Why do I have to do this? You don't have to do it. But if a creditor is a bad actor, we can just file your case. We can give you advice about the law. We don't have the power over people to make them follow it. I wish we did. Some clients have the expectation that we can do that. If I had power over people, I would, who knows what I would be doing, but I can't. Some people break the law. Some people abuse the law. They're not going to follow the bankruptcy process. And we have to establish a pattern and practice of them sending something, us notifying them, and they continually willfully violate that over and over and over again. And if that's the case, then we're going to need to do something about it. And in order to do something about it, we need that evidence to file potentially a lawsuit and potentially get this stopped. Because mainly we want to get it stopped. And then if it's been causing damage or aggravation, then we'll want to get compensation for that as well. Okay? All right, so now we've covered most everything related to after Chapter 7. It's not really that difficult. The hard part is getting all the bankruptcy schedules together. And then after you file the case, you have to complete the financial management course. Here's a little checklist. Check, get out a pen and paper, write it down. Just filed a Chapter 7. Number 1, complete my financial management course. Number 2, make sure I attend my 341 meeting. I provide all the documents that the attorney needs to provide the trustee, and I attend that meeting and complete it. Number 3, if you need to do a reaffirmation agreement, make sure that you're communicating with the law firm and getting that information back in a timely manner, and wait for any creditors to potentially file an objection. And then after that objection deadline expires, you're discharged.
Yeah, super simple.
Yeah. Why did we talk so long?
I don't know.
Yeah,
Chapter 7 is really, I mean, it's really quick, and there's really very little work that you have to put into it. It's just, like I said, a partnership. So make sure that we're working together to get you through it.
So it's an attention to detail. We want to make sure that we're letting you know all the details, holding your hand through the process, and you've paid the funds, you've made the step, you put in the effort. We want to get you across that goal line and get you that discharge. All right. So now we're going to switch gears and we're going to talk about Chapter 13. So you just filed your Chapter 13 bankruptcy case with Allmand Law Firm. What should you expect? What's going to be happening? We're great information for you right now, and we want to share that with you about what to expect. So number 1 is you're going to need to make sure that you provided all the documents to our law firm that we need to be able to provide the Chapter 13 trustee to conduct the hearing. So recap me and tell me what that's going to be.
Yeah, so we're going to need your identity verification. So your state issued identification and social security card.
Right.
We're going to need the last 2 years of filed tax returns. We're going to need the last 60 days of income. And then if you file state exemptions, we're going to need your bank statements showing the amount of money that was in your bank statement and the date that your case was filed.
Okay, that's great. I'm going to run through those again because Danielle absolutely is correct. So you just filed your case. You need to keep track of all of your pay stubs. Start saving them. So if as soon as the case is filed, we need you to save those pay stubs. They have to see the pay stubs after the case is filed. Now you gave them to our office before filing, but we didn't get them afterwards. So you can save those. You can upload those directly to the law firm through the portal. We're going to need that. Also, under the bankruptcy code, the debtor has an obligation to make sure that they have on file with the IRS their last 4 years tax returns. So if you have not filed tax returns in the last 4 years, you're going to have to get them filed. It's a requirement to be able to proceed with the case. If you wait to do it until the day before the 341 meeting and then you can't get to it and you go to that meeting, they're not going to conclude your meeting. They're going to pass it, and they're probably most likely going to file a motion to dismiss the case. And give you one more chance to get it in. So make sure you get that filed. Go to the irs.gov, watch our other video on how to navigate through the IRS system to get those pay stubs or W-2s to complete those documents. Did I say pay stubs? What I meant to say, the IRS, either tax returns or the W-2s and 1099s.
There you go.
Okay. And then you're going to need to make sure you attend. And so at the time of recording this in August of 2020, the U.S. Trustee has extended the deadline for telephonic or Zoom meetings. Here in the Dallas-Fort Worth area, we're doing Zoom conferences with clients. So any case filed up through the middle of October of 2020 is going to have a virtual meeting. Traditionally, on the notice of the meeting, it gives you a date and location for you to show up. It's not going to be at the court. It's going to be at the trustee's office, which is typically a professional building, which you're going to enter, go into a suite, and then there'll be a cubicle with the hearing officer there.
Yeah, in your 341 meeting of creditors notice, it's going to have a date and a time. Your date is absolutely going to be the date of your 341. The time is going to be a little bit more flexible. It will still be in the AM or PM based on whatever it says on there. But the 341s are in increments of anywhere from 15 to 30 minutes. And so your Zoom invite for your personalized meeting is going to have a different time.
Right.
And all that information is provided to you well in advance. And then if you don't have the technological capabilities of doing that 341 meeting on your own at home by Zoom, through your phone or through your computer, you absolutely 100% can come to our office and we will help you log in and be ready for that meeting too.
Yeah, absolutely. So that meeting of creditors is the first major step coming up in the bankruptcy case. Some other major steps coming up is since you're in a Chapter 13, it requires you to make payments. A payment is due every month. And the payment is based off of what we filed with the bankruptcy court on the plan. And so the first payment due date is determined based on the date the case is filed and 30 days later. A common question that we get from clients is, I want to change my payment due date. I would like to pay it on this day or this day. Unfortunately, we don't have the flexibility to change your payment due date. It's set under statute as the date of filing the case. Now, if their payment is due on September 1st and we're in August and you want to make the payment in increments, you can do that as long as the full payment gets there by September the 1st. And so we need to briefly touch on how can you make your bankruptcy payment to the trustee? What methods can you use to make sure the money gets there? So we're going to run through those real quickly. Number one, I should say, it can vary by Chapter 13 trustee. Each Chapter 13 trustee has different roles. So some of the options that I'm going through right now may not be the option for your Chapter 13 trustee. The trustees in the Dallas division of the Northern District of Texas allow you to make your payment by wage directive. I shouldn't say allow you, they require you to make your payment by wage directive. And so what that means is you fill out a form, you list your employer's name, the payroll department contact number, their address, their phone number, their fax number, and you the trustee will send a notice or an order over to your employer to start deducting your bankruptcy payment directly out of your check. So if your bankruptcy payment is $400 and you get paid every other week, every 2 weeks, or I should say potentially semi-monthly, and maybe get paid on the 1st and the 15th, they'll take $200 out of your payment, your paycheck on the 1st of the month, and $200 out of your paycheck for the second pay period that month. So it'll total $400. And so that wage directive goes into effect on the 3rd payment of your bankruptcy case. So the first 2 payments you have to make by an alternative method. So what is those alternative methods to make your Chapter 13 trustee payment? Number 1, you can make it by sending in certified funds. Certified funds are a cashier's check, a money order. That means that it's good upon receipt, that they don't have to wait for it to cash. Personal checks are not accepted. That certified funds has to be mailed to the trustee's P.O. box. The trustee does not accept those funds directly. As you can imagine, that's the potential for hazard or somebody being abusive. So it goes to a P.O. box at a bank. They open it up. They apply it towards a file. What could possibly go wrong with sending a money order cashier's check to a P.O. box?
So, and the crazy thing is the P.O. box is in Tennessee and we live here in Texas, right? So, making it by a cashier's check or a money order and mailing it, you're running into now the mail service. How long does it take to get there? And then it's going to take 10 to 12 days to process that payment once it is received. So now you have to think ahead, right? If my payment's due on the 1st, I got to think ahead at least 15, 16 days in advance. That check needs to be in the mail before then, so that the payment is posted by the 1st.
Right. And so that payment period is sort of a worst case scenario. It may get posted sooner, but currently right now, August 2020, with our mail situation, my personal mail is delayed by 2 weeks. And it's taking 2 weeks longer than it normally takes for stuff to get there. So you'll have to factor that in, exactly what you said. The other thing, another tip for mailing in your certified funds is you have to include your case number and your name on there. If you just send in a blank wage directive or money order or cashier's check, they don't know who it goes to. And so you need to save all of these payments to the trustee as well in case that situation happens, because they log all of the numbers on the cashier's checks and the money orders, so then we could research that if it happens. So put your case number on there. So that is the one way. Another way to make your trustee payment is through a company called TFS. And so TFS Bill Pay is a private company, and they allow you to set up an ACH to come out of your bank account. And so that's one of the things they provide. And so you'll fill out a form with them, you'll register, we can help you do that. And they can say, okay, I'm going to debit this person's account on the 1st and the 15th, take out $200 each time, so that by the time their payment rolls around, they're going to be current. Now with TFS, as Danielle mentioned with the money orders, once they make that transfer, they have to sit and put a hold on that money to make sure it's good funds and that there's not a chargeback, and then send it on to the trustee. And so that can be up to 10-day hold on those funds before it gets through there. So if you're under a time-sensitive situation, you need to make sure to do it. Because the reason why we're telling you all this is because if the first payment is not in there by the due date, it triggers an automatic notice of intent to dismiss within 48 hours of the case. They don't play games on that first payment. So you got to make sure you're working ahead. Another alternative, which is the fastest and most safe, verified form of payment, is also through TFS, through their MoneyGram option. And so what that is, you register with TFS to set up your account, your information on how to send your MoneyGram account. You can go to any Walmart or any location that has MoneyGram. You can give them the information, the identification that they need in order to process that, and then it's immediately in your case. So the trustee will give you immediate credit for that. You don't have to worry about anything. Go ahead.
Yeah, so those first 2 payments before you're on your wage directive, if your area requires it, you're on the hook for first two payments, right? And so we kind of have the good, better, best payment options, right? So the money order and the cashier's check is a good option, but you have to really budget your time for that. The better option, right, is TFS bill pay. So you can set up that automatic payment to come out. You don't even have to think about it. It's done, and they'll take care of it on their end. Does have a time delay as well because they do hold the funds for a little bit. And then the best option is MoneyGram because it is an immediate 100%, it's done, it's posted, the trustee has the funds on hand, right? And so, I mean, those are your three options for those first 2 months. After that, and you're placed on the wage directive, then it's taken out of your paycheck.
Right. And the only drawback, I guess, about the MoneyGram, potentially what people think is that there's an extra fee associated with that. Do you happen to recall what that is?
I want to say it's like $6.99 or $8.99. It's somewhere, it's under $10.
Right. And so there is the funds. Now, what you also need to factor in is that if you're going to be sending a cashier's check on money order, you have to factor in the cost of paying for the money order or the cashier's check, plus the cost of sending it by mail. And we recommend that you don't just send it by first class mail, you do some type of certified delivery. You don't want to require a signature because that can delay it, but you want to make sure the funds got there, because if you put $1,000 in a money order in an envelope and send it off and they say they didn't get it, you don't know where the envelope went. So if you consider those two costs, the MoneyGram is the fastest and pretty much a comparable solution for that. All right, so we went over that. We need to make sure that for your trustee payment, some quick tips to recap is, number one, you got to make your payment timely. You got to plan for your first payment before the due date, because you need to be withholding the funds from your checks that you receive after you file and making sure you're sending a proportionate amount into the trustee. Number two, you need to use one of the verified methods that we discussed and make sure that you follow the steps for each verified method. And number three, it's got to get there before the due date because we don't want your case to get dismissed.
Right.
All right. And I guess potentially number four, you have to get that wage directive filled out. So that wage directive form has to be turned into the trustee, or that will also potentially cause a motion to dismiss. All right. So those are some specific things right for a Chapter 13. So Michelle, how can I feel confident about what is going on in the case? Did they get that payment I sent in? Am I behind on my payments? You know, obviously you can contact Allmand Law Firm. You can email us at questions@Allmand Law Firm and we can research and get it back to you. But what if you want instantaneous access?
Yeah, so there's this great free website that's available to you. It's ndc.org, and you can register on there to really track your payments, look at your payment schedules. You can see what the trustee has paid out to the creditors. It's convenient 24/7 access for you at any time. So you don't have to rely on us to get the information for you. You can see everything that's happening there. You'll get automatic alerts if your payment changes, right? So sometimes your payment might go up or down based on how your payment plan is structured. And you will be aware of that before it happens. So you can make adjustments when you need to. So it's a free website, super easy. The website actually says it takes less than 5 minutes to enroll. So we also have a step-by-step guide on how to enroll.
Yes. So we give you written instructions, and also we have an additional instruction sheet we can give you, and we'll also provide a video with the screenshots on how to do that. But NDC stands for National Data Center, and they compile all the information directly from the trustee's website. So this is information that's not available on the court site, which is Pacer. This is the back end of the trustee's website. So you can basically log in, get a login and password to go into the back end of your trustee's website and see everything that's happened in your case in real time.
Yeah.
So
and
that's
you can,
incredible.
yeah, you can see the claims that the creditor has filed. You can see who the trustee has paid, when they paid it. You can see when your payments were posted, because you know you made the payment, but it's not showing yet. Mm-hmm. And so it's all really good, convenient information for you to have.
Yes. Because the reason why we're spending so much time on this issue about payments, it's the number one reason why Chapter 13s don't succeed.
Yeah, I mean, it's so super important, right? Is how your case progresses. You don't want to be several months in and you miss a payment and you just lost everything you just worked for, right? And so making your trustee payment is the most important thing in your Chapter 13 case.
Okay. But what if I can't make the payment? You know, something's come up, I just can't afford to make the payment. should I just bury my head in the sand and hope it passes over and nothing bad happens?
No, so we don't want to get into the same situation we had before you filed, right? And so please let us know if there's any kind of change of situation or extenuating circumstances that make it such that you can't make your payment. We can meet with you and we can talk about options for how do we get it corrected for you. So there's many options that are available, and please reach out to us and let us know so that we can partner with you to take care of it.
Yeah, because based on some certain qualifying questions that we'll go through, and based on the stage of the case, we may be able to let you defer a payment, catch up on a past due payment, lower payment temporarily, whatever we can do to help you try to be successful in that bankruptcy case. We want to make sure that it happens. All right, so we now have gone over what to expect about your 341 meeting, how to make your first trustee payment. When you're in a Chapter 13, do you have to do a financial management course as well?
You do. So it is a requirement, no matter what chapter you're in, that you have to do a financial management course. The sooner you get it done, the better. We want you to absolutely utilize the same course that same vendor you used when you did your credit counseling. Enter in your attorney code, get your discount, and they will automatically file it for you. Let's get it taken care of as soon as possible. We don't want to be 4 years in and forget that we did it or didn't do it and have to scramble to get it done. Yeah, exactly.
And so something else that's interesting is there's some trustee jurisdictions in Texas. I think the majority of the jurisdictions in Texas do what's called a conduit bankruptcy case. There's some jurisdictions that don't, but basically a conduit bankruptcy case means that your ongoing mortgage payment that comes due after your case is filed, you also pay that to the Chapter 13 trustee, so then they can turn around and make your mortgage payment for you. So in that situation, your bankruptcy payment and your mortgage payment would all be rolled up into one. And in order for this conduit to be successful, there are some required forms that everybody has to fill out, even if they don't have a mortgage. And can you tell me about what those forms are? Got the mortgage information sheet?
Yes.
Yeah.
The mortgage information sheet. So the mortgage information sheet, we're providing to the trustee who is your mortgage company, what is the account number, what is the mailing address, so that they can go ahead and make those payments for you. It is required to be signed by you or one of our attorneys. And then we have an authorization form that is sent to the trustee where they can pull the information for any of your secured creditors, which does have to be signed by you as well. So those two forms are required very quickly after your case is filed.
Okay, so we've really made an effort here to provide you this video to let you know what you need to do right after you file your Chapter 13 up to your 341 meeting. Do you think there's any other final tips or strategies we can think of for people in that stage of the case that they should be aware of or consider or attend to?
I think if you notice that there are any creditors that you forgot to add, we just need to know that information so that we can add your creditors. If it just slipped your mind or you received a statement after the fact, so that we can add them before your 341 meeting too.
Exactly. All right. So we missed that, but I want to make sure we go over that. Yeah. So if you get a notice from a creditor or you realize that, hey, I forgot to list to somebody, it's critical in a Chapter 13 case that you immediately get your bankruptcy schedules admitted to add them, because if they're not added early enough in the case and they don't have an opportunity to file a proof of claim, that debt will be prevented from being able to be discharged. And so the process for that is you send us the name, address, account number, amount you owe, when you incurred the debt. That's the information we need to prepare the bankruptcy schedules. And I said that really fast. So I'll do name, address, account number, how much you owe that person, and when you incurred that debt. We amend your bankruptcy schedules. You have to sign off on that electronically or in blue ink. We have to get the blue ink on everybody. Then once we have that, we can file it with the court. The court charges a $31 fee that you have to pay to our office to get that done. The $31 fee is every time we make an amendment. So whether we're adding 1 or 10, it's going to include all those. All right. So, well, thank you so much, Danielle. I really appreciate it. Thank you guys for retaining Allmand Law Firm. And letting us help you walk through these first steps of your Chapter 13. You're going to be very successful. I hope you find this information helpful. If you listen to this and follow our tips, the chances of you being successful are greatly improved. If you have any further questions, feel free to let us know at questions@allmandlaw.com or visit our website, allmandlaw.com or creditandbankruptcy.com. Thank you and have a great day.